Thank you, Mr. Justice Witt. Hearing of the 12th Annual Caribbean Court of Justice International Law Moot in the matter of Vincent Limited and St. Vincent and the Grenadines. The members of this morning's panel are Mr. Justice Witt, presiding judge.
Good morning, Counsel.
Mr. Justice Anderson.
Good morning, Counsel.
And Madam Justice Raj Nutley.
Good morning, Counsel.
May we have the appearances, please?
Good morning, Mr. President, honorable judges. May it please the court. Senior Counsel D'Angelo Lala appears for the claimant, Vincent Limited, in this matter, and I am with him. My name is Shalini Ali. Senior Counsel will address you first.
Thank you, and good morning, Mr. President, honorable justices, and may it please the court. I am D'Angelo Lala, appearing as senior counsel for Vincent Limited in today's proceedings. We are adamant in our submissions that the state of St. Vincent and the Grenadines have unlawfully breached both their international...
Mr. Lala, please. I didn't hear the appearance. I didn't see or hear the appearances for the other side, so maybe we should go there first.
I'm guided.
May it please this honorable court, I am Kimberly Blackwood and I appear as senior counsel on behalf of the defendant, St. Vincent and the Grenadines. And with me today is my co-counsel, Ms. Shaquan Richards, and we are instructed by Ms. Aika Dorival.
Okay, thank you. I don't think we see you. Did you put your camera on?
Yes, Your Honors. Are you able to see me?
No.
Crave your indulgence, Your Honors. Is the court able to see me now, Your Honors?
Still not. But your camera seems to be on, but we don't see you.
Crave your indulgence, Your Honors.
Mm-hmm. I suppose it has been tested, so.
They can see us.
May it please this honorable court, is this honorable court able to see me now?
Not yet.
No, we're not, but I gather, Chair, that there are some persons who are able to see counsel. So it may be an IT problem, which requires an IT solution.
Okay, maybe we will, in the meantime, I hope you will be online to hear what the other, what the claimant counsel are saying. But maybe in the meantime, the technical people can solve this problem. Would that be all right with you? Counsel?
Yes, Your Honors.
Sorry, we assume that you can see us and opposing counsel.
Yes, Your Honors, we're able to see the honorable justices and opposing counsel.
Very
Okay, well, as long as you can hear them too, and of course our questions and their answers, then there won't be a big problem. And once it's your turn, then yeah, we hope that this problem has been solved.
Grateful.
So we now can proceed, Mr. Lala.
Thank you, Your Honor. Good morning, Mr. President, honorable justices, and may it please the court. I am D'Angelo Lala, appearing as senior counsel for Vincent Limited in today's proceedings, and we are adamant in our submissions that the state of St. Vincent and the Grenadines have unlawfully breached both their international and domestic obligation with regards to the mandatory referral obligation of Article 214 of the revised Treaty of Characterize. As such, the defendant is liable as a state in international law for the failure of its national courts and tribunals to adhere to this fundamental and mandatory referral obligation. In taking these steps that it did, the defendant not only usurped and infringed upon the exclusive and compulsory jurisdiction of this very court, but it did so with scant regard to the law, to the detriment of a CARICOM entity, and directly causing substantial and calculable losses. Your Honors, over the course of the next 20 minutes, I will discuss 5 substantial submissions, following in the order of point 1 of the claimant's first written submissions in these proceedings. Thereafter, my colleague, Junior Counsel, will discuss the mandatory nature of Article 214, showing that it's an obligation which St. Vincent and the Grenadines cannot simply ignore. Your Honors, this issue is being tried in a very interesting time. Various events taking place around the world speak to it, and it places these proceedings under a unique spotlight, with specific regard to the importance of states in adhering to their international obligations, as well as the very real and grave danger which exists when they not only fail to do so, but willfully disregard it. And therefore, in that same vein, Your Honors, we submit and respectfully ask of this court that the defendant's breach of Article 214 should not be taken lightly, as it has the potential to totally undermine the unification of our cherished Caribbean community. Now, with that said, Your Honors, I will now proceed into my substantive submissions, starting firstly on the classification issue. And in this regard, we submit that the classification of the claimant's cement product for the purposes of applying a tariff directly concern the application of the common external tariff of the revised Treaty of Chaguaramas, and therefore this issue fell into the exclusive and compulsory jurisdiction of this court and this court alone. And therefore this issue necessitated referral, and St. Vincent and the Grenadines were obliged to have referred to this court in handling this issue. As established by Article 82, and for the purposes of furthering economic integration across the region, the common external tariff is a foundational economic instrument of the Caribbean community. Having regard to the fact that St. Vincent and the Grenadines is a member state of the RTC, as well as the claimant, Vincent Limited, is a CARICOM entity being a duly incorporated business within a member state. The classification of the claimant's cement product, which was being imported from outside of the region, from a third country, from Turkey, classification of the claimant's cement product directly concerned the application of the common external tariff of the revised Treaty of Chaguaramas, and therefore this issue directly concerned the interpretation and application of the revised Treaty of Chaguaramas in itself. The common external tariff is a critical economic component of this treaty. And therefore, as my learned friends in their submissions have asserted, they claim that the defendant's national courts and tribunals were only acting in their afforded discretion. However, Article 211 is sufficiently clear in this regard, where it explicitly sets out that any matters which concern the application or interpretation of the revised Treaty of Chaguaramas falls within the exclusive jurisdiction of this court. And therefore, further, Article 214 does not offer the discretion to any member state, much less the defendant, the ability to usurp the exclusive jurisdiction of this court. Instead, Article 214 obliges the national courts and tribunals of the defendant to refer this issue for determination.
Counsel?
Yes, Your Honor.
Yeah, I was just wondering about the very dramatic way in which you started, and what you suggest is at stake here, the very survival of the community. Now, bearing in mind that the courts of St. Vincent and the Grenadines, certainly the state, has agreed to apply the decision of this court as regards the classification of the cement. Is it danger that you have posed to us with hints of what's happening in the wider world? Is it justified in the circumstances here where the courts in St. Vincent and the Grenadines have already agreed that they will apply the classification decision? Is what before us not a much narrower and more self-contained issue than you are suggesting?
Yes, Your Honor, and thank you for your question. And we contend that it is as serious as I explained, because notwithstanding the fact that the defendant has accepted the classification, they did so at a late stage of the proceedings, and the defendant, or rather the claimant, had already suffered substantial losses as a result of the defendant's failure to refer this issue when it first came before its national courts and tribunals. The fact of the matter is, Your Honor, they should have never had to pay this unlawful tax in the first place, and it is as a direct result of the defendant's failure to refer this issue to this court, which led to this substantial breach. And therefore,
you counsel never asked, or the persons representing your clients never asked for a referral, did they?
Yes, Your Honor, that is true. The claimants did not ask for a referral, but however, we submit that there should not be a heavy reliance on this because the state was also present at each stage of the proceedings, and they too did not ask for a referral. In addition, the national courts and tribunals did not address the issue of referral at any stage of the proceedings, and therefore we contend that this is a non-issue, it's a red herring. Fault should not be solely placed on the claimant for failure to raise this issue of referral. And in addition, by means of Article 214 and its express wording, the obligation to refer is placed upon the national courts and tribunals of the member state of the defendant, and therefore the claimant should not be faulted for not raising this issue of referral at trial. And therefore, to return to Article 214, we contend, Your Honors, that it is inconsequential and immaterial whether the national courts and tribunals of the defendant held a genuine belief that they could have decided this issue without a determination from the Caribbean Court of Justice. The fact of the matter is, Your Honors, those courts had absolutely no jurisdiction to decide. Notwithstanding this, they went on to classify the claimant's semen anyways, overstepping into the exclusive jurisdiction of this court. They came to an incorrect conclusion, as was subsequently held by this court in the Rockard distribution case, and as was subsequently acknowledged by the defendant. And
Counsel, sorry, but I'm still a little bit uneasy about the line that you're taking, because it seems to me that the wording of Article 214 suggests that the referral obligation arises when the national court is seized of an issue which concerns the interpretation and application of the revised treaty of Chaguaramas. Now, how is the court going to be seized of that issue if it's not raised before the court?
Your Honors, by the express wording of Article 214, we contend that this is a mandatory provision in that as long as this issue directly concerned the application or interpretation of the revised Treaty of Chaguaramas, which it did in this case, the obligation fell on the national courts and tribunals of the defendant to refer this issue. And therefore, it's immaterial whether they held a genuine belief that they could have decided this matter without a determination, or whether they wanted to rely on the claimant to raise the issue of the referral. The fact of the matter is the obligation rests on the national courts and tribunals of the defendant, and as long as this issue directly concerned the RTC in itself, they had an obligation to refer this issue to this court.
I'm sorry, my sister wanted to ask the question.
Oh, thank you so much, Judge. Mr. Lala, are you saying then to us that whatever discretion there is to refer, not to refer, is not founded then on whether or not whether or not a question concerning the interpretation or application of this treaty has been raised? Is that where the discretion arises from, the words of that part? Or is it that if the court considers that a decision on the question is necessary to enable it to deliver judgment? I'm reading from Article 214, and I'm trying to find what you make of those things. That, as I understand you, you're saying that once the question concerns the interpretation or application of the RTC, then it must be referred. There is no further discretion. You following me, Mr. Lala?
Yes, Your Honor, and we agree with what you said. That is our position. We contend that this is a mandatory referral obligation, and as long as this issue dealt with the RTC in itself, was mandatory for the national courts and tribunals to refer this issue to this court in respecting the exclusive and compulsory jurisdiction of this court's original jurisdiction. And therefore, to find that this issue was not one which was suitable for referral is unreasonable on the defendant's national courts and tribunals. And therefore, we contend.
But you know, Mr. Lala, the equivalent provision in Europe suggests that the obligation arises when the question is raised in the proceedings. I think if you look at, is it Article 267 of the treaty in Europe, there's a reference to the question being raised in the proceedings, and then that is what triggers the referral obligation. Now, the question was not raised by either side in these proceedings in St. Vincent and Grenadines. So in that sense, could you not say that the court there was not seized of the issue because it was not brought to their attention?
Your Honors, yeah, we acknowledge that this issue was not raised by the claimant. However, as I mentioned before, we contend that this is a non-issue because the state in itself did not raise the issue, and they were at present at every stage of the proceedings, in addition to the fact that Article 214 places the obligation on the national courts and tribunals of the state to refer. Notwithstanding that referral and raising this issue of referral may be beneficiary, the fact of the matter is the express wording of Article 214 states that where an issue directly concerns the RTC, the obligation is on the national courts and tribunals of the defendant to refer this issue. Therefore, notwithstanding that referral was not raised by the claimant, the obligation still remains upon the national courts and tribunals of the defendant to refer this issue as it directly concerned the application and interpretation of the RTC and fell into the exclusive jurisdiction of this court. And therefore...
Thank you, Counsel.
Then, yes, in answer to my brother, you seem to be suggesting that we ought not to adopt or consider weighty the European position on that. That's how I understand you. Is there a reason you think that ought not to be adopted here?
Yes, Your Honor, and we contend that the circumstances in the European Union are much different from the circumstances in the Caribbean region, and therefore we contend, and based on the express wording of Article 214, which is sufficiently clear in itself, there is no need for the claimant to raise this issue of referral. The national courts and tribunals of a member state ought to be aware of their international obligations with regards to this mandatory referral obligation. And Your Honors, I would just like to mention that this topic that you raised would be better handled by my junior counsel, and for the purposes of time, I would like to just continue with what I plan to say.
Thank you very much, Mr. Lala.
Yeah, Mr. Lala, I think you're right. I think what you're trying to say is that the issue that the courts were seized of was the Article 82 issue, and that touched on the interpretation, of course, of the revised treaty, and you're saying that should have been referred, but that is a topic that will be dealt with by your junior. So let's go to the liability. Supposing that there has been a duty to refer, we will hear your junior about that. What creates the liability in this case?
Precisely, Your Honor.
And how is it circumscribed, if at all?
Yes, Your Honor. And that takes me to my second substantial submission on the issue of incorporation. And in this regard, we submit that the defendant incorporated the referral duty into its domestic legislation, and in doing so, it willingly limited the ability and sovereignty of its national courts and tribunals to adjudicate on issues which concern the revised Treaty of Chaguaramas.
Mr. Lala, just an interesting aspect. Suppose they had not incorporated it. Would that make any difference from the perspective of this court as an international court?
No, Your Honor, that would make no difference. This court is an international court, and St. Vincent and the Grenadines, being a member state of the revised Treaty of Chaguaramas, willingly agreed to be bound by certain rules and regulations, which include the mandatory referral obligation of Article 214. But in addition to this international obligation, the defendant, by virtue of Section 6, subsection 1 of the Caribbean Community Act, Chapter 184, Act Number 5 of 2005, voluntarily incorporated this referral obligation into its national legislation, and therefore this obligation to refer exists on two separate fronts, both of which are binding on the defendant. This is not some mere obligation which exists in international law, but it goes part and parcel with the national legislation of the defendant, and therefore its actions in failing to refer, at its very least, a state is expected to follow its own law, and its actions in failing to refer is nothing short of a dereliction of duty by a sovereign state, which directly causes the substantial losses as suffered by the CARICOM entity in these proceedings. And therefore, this takes me to my third substantial submission on the issue of attribution. And in this regard, we submit that the liability for the breach committed by the national courts and tribunals of the defendant in failing to refer should be attributed to St. Vincent and the Grenadines as a state in international law as a single entity. Your Honor, to effectively protect the rights of CARICOM nationals, it is indispensable that member states be held liable for the breaches committed by their national courts and tribunals. Therefore, in relation to Article 214, the obligation to act, the obligation to refer, which is placed upon the national courts and tribunals of the defendant, where there is a breach or failure to act, as in this case, the liability which naturally follows, we contend, should be attributed towards the state as a single entity, keeping in mind that the judiciary is an indisputable organ or limb of the state. And this principle is gleaned from a very persuasive authority based on the ECJ ruling in Kobler against Austria, where at paragraph 32 it was held, and I quote, in international law, a state which incurs liability for the breach of an international commitment is viewed as a single entity, irrespective of whether the breach which gave rise to the damage is attributable to the legislature, the judiciary, or the executive. And therefore,
didn't Kobler, Mr. Lala, go on to indicate additional conditions to be fulfilled where the breach is attributed to the decisions of a domestic court? Didn't it, for example, use the term that it's only in exceptional circumstances that there be liability? Didn't it say that the breach must be intentional and so on? So if you're going to use Kobler, how would you incorporate those additional elements?
Yes, Your Honor.
Where the decision of the domestic courts are concerned?
Yes, Your Honor, and we contend that the additional liabilities which is placed on this principle by the ECJ, notwithstanding this principle is a reasonable and logical principle which follows from the principles of state liability as established by this court. And notwithstanding those limitations which were presented by the ECJ, liability will still apply to the national courts and tribunals to be attributed to St. Vincent and the Grenadines in these proceedings.
But would you say that the breach here by the national courts was intentional, for example?
Notwithstanding,
was that intentional?
Notwithstanding intention, and I must say that I do believe that the breach was intentional. But notwithstanding this, the fact of the matter is that they failed to refer this matter, which was a mandatory obligation in both the domestic and international obligations. And therefore, Your Honors, to move quite quickly to my fourth substantial submission on the issue of state liability, as established in TCL and TGI against Guyana, in particular paragraph 27, when the court held that a party will have to demonstrate that the provision alleged to be breached was intended to benefit that person, that such breach is serious, that there is substantial loss, and that there is a causal link between the breach by the state and the loss or damage to that person, we contend that all four conditions are satisfied. Firstly, Article 214 was intended to benefit the claimant in that it would have ensured that the claimant's product was properly classified and subject to an equitable and fair tariff. Furthermore, the referral procedure would have allowed the claimant to address his concerns with the competent court of jurisdiction, saving years and months of paying this unlawful tax. Secondly, the defendant's breach was sufficiently serious. In doing what they did, the defendants breached their international obligation, their domestic obligation. In classifying the claimant's cement product, they overstepped into the exclusive jurisdiction of this court, and they subsequently came to an incorrect classification, which they acknowledged and which was subsequently held by this court. And then they forced this additional tax payment onto the claimant for 3 years, 4 months, and approximately 21 days. By the very nature of the CET, it's a tariff which is put in place to disincentivize and discourage the claimant's business, which involved extra regional imports. And as a result of the defendant's actions, the claimant had to pay an additional tax on top of this. Fourthly,
Mr. Lala, now this goes back to a liability in damages, which has these four conditions. But I also see that alternatively, at least, you also go for reimbursement, restitution. Is it that these conditions are also necessary when we talk about restitution?
Your Honor, we contend that these principles, state liability for damages, as well as unjust enrichment, are not mutually exclusive, and that the claimant can bring forward these two principles in favor of its case in order to gain compensation as well as damages for the egregious and blatant breach committed by the defendant in these proceedings. And therefore, Your Honors, to finish that third point that I was making, the claimant did in fact suffer substantial damages. They had been forced to pay this additional tax for 3 years, 4 months, and 21 days, which has been disastrous to their economic portfolio. And fourthly, there was a direct causal link between the defendant's non-referral and the additional tax payment. It was solely due to the fact that the defendant did not refer this issue, which resulted in the inaccurate classification, which resulted in the years of paying this unlawful tax by the claimant. And therefore, we contend that the four conditions for state liability are in fact satisfied. Moving quickly along to my fifth and final substantive submission.
Actually, you're out of time, but we detained you a little bit long on the other subject, so I will give you 3 minutes to finish your last point.
Thank you, Your Honor.
That is also, of course, to good for the other side, so that they know what to react on.
Yes.
Yes.
Thank you, Your Honor. And on this point, on unjust enrichment, we contend that the defendant is liable for imposing an unlawful tax on the claimant and must reimburse the claimant for this additional tax payment. This is the claimant's strategic alternative argument, should the court not be inclined to follow our arguments in favor of state liability. We've put forward a separate and alternative principle by which the claimant is entitled to reimbursement for this additional tax payment it had been forced to pay. And we contend that the defendant, in breaching its international and domestic obligations, in usurping the exclusive jurisdiction of this court, in coming to incorrect classification and enforcing that classification upon the claimant, on top of the CET, which by its very nature is there to disincentivize the claimant's business. We contend that this is not only totally unfair, but it culminates and can be properly classified as wrongful conduct for the purposes of the principle of unjust enrichment, as was applied by this court in SM Jalil and Company against Guyana and in Releasa Beverages against Guyana. So too in those cases, the claimant had no right to pay this tax in the first place and is entitled to a prompt reimbursement. And that takes me to the end of my substantive submissions, Your Honors. And in conclusion, I want to briefly re-emphasize the sheer importance of Article 214 to the Caribbean community.
I think, Mr. Lala, we are certainly aware of the importance of the article. I think you concluded your remarks. We are, as I said, somewhat over time. So I think it's clear. So it's now to Ms. Richard. To Ms. Ali.
Good afternoon, honorable judges. May it please the court. My name is Shalini Ali, and over the course of the next 15 minutes, I will be submitting that there was no discretion on the part of the courts of the defendant as to whether or not to refer the issue of classification to the Caribbean Court of Justice. Before I enter my substantive submissions, I would like to first address the question posed by Your Honors to Senior Counsel, which is the question of seizure. Your Honors, the nature of the matter was so obviously under the scrutiny of the Caribbean Court of Justice as it's related to the classification of the common external tariff. And the courts had an onus to be appraised of their state's international obligations. It was simply unreasonable for them not to refer the issue. They were clearly seized with the issue, where this court had litigated extensively on the classification of the common external tariff, as I will demonstrate through my substantive submissions. I'd also like to address the question of the discretion under the European Union. We acknowledge that the European Union referral mechanism does afford a measure of discretion. We do not believe that all the principles containing the referral mechanism should be transplanted directly into Caribbean jurisprudence. And we also recognize that in the case of SM Jalil and Guyana, this court at paragraph 29 recognized that they need not show a level of deference to the domestic courts that is required in the European Union. This court is the central judicial authority on all matters under the revised Treaty of Characterize. Your Honors, This is a case where the defendant neglected its referral obligation to its highest courts. The defendant consented to be bound by the revised Treaty of Characterize, limited its sovereignty in respect of the application of the common external tariff and the classification of its imports, incorporated that referral obligation into its domestic legislation. Yet, when it was called upon to adhere to its domestic and community obligations, the defendant failed to do so. Our first submission is that the obligation imposed by Article 214 is mandatory in the context of the terms of the treaty and in accordance with its object and purpose. Article 31.
Thank you for responding to questions that were asked of Senior Counsel, but I'm afraid, a little troubled by the way we are proceeding, because you are conceding that in the judicial review proceedings, there was no mention of the RTC. There was no mention of quota. Similarly, in the Court of Appeal and before the Privy Council, no mention of these entities. So if there is no mention of the community, if there's no mention that there is a community law issue in play, how is the local court going to become seized of the issue? I'm still trying to follow you and follow Senior Counsel as well on this point. Can you help me any further on that?
Your Honor, the onus was on the National Court to be seized of the issue based, if they were the parties that were to consider any questions for referral. They were the parties that were to be aware of the community obligations, and they were the parties to prepare and execute the referral. The onus wasn't, we agree that a litigant has a duty to assist the court, but that duty to assist does not absolve the court's ultimate duty to refer. Essentially, the claimant cannot be in breach of the court's duty.
But but you're admitting that the claimant and the claimant's lawyer does have an obligation to assist the court in the discharge of the court's duty.
Yes, Your Honor, every litigant does have a duty to assist, but the revised treaty explicitly placed that onus of referral on national courts and tribunals. And
when they are seized of the issue, yes.
By the court itself ought to have been seized of the issue based on the fact that it must interpret its law in accordance with international obligations. That was outlined by this very court in the case of Boyce and the Attorney General. So it was the court that needed to be aware and make the referral.
Yeah. Thank you, Counsel.
But let's be precise about the issue of which the court was seized. What is the issue they were seized of?
Yes, Your Honor. When claimants engaged the National Court, it's the High Court, on the issue of judicial review, the claimants engaged the question of whether the Comptroller of Customs and Excise of St. Vincent and the Grenadines had executed the proper procedure in classifying the cements. It was a question of...
And you're saying that question could not be answered just by applying domestic law. They should have seen that that is a matter of the CET and that is a matter of interpreting the revised treaty. Is that what you mean?
Yes, Your Honor.
And that they therefore had to refer?
Yes, Your Honor. The question of procedural propriety also engages the concept of jurisdiction. And for the court to determine whether the comptroller had in fact carried out the proper procedure, the court should have stayed the matter and refer the question of classification to the Caribbean Court of Justice or quoted an RTC organ to determine whether the comptroller had the jurisdiction to classify the cement in the first place. And then the court could have rendered a decision as to whether the comptroller had carried out the proper procedure in accordance with law. I return to my substantial submission on the context of the terms of the RTC and its object and purpose. Article 214 uses the word shall. and shall is used throughout the RTC to impose obligations and duties, non-discretions or permissions. If we consider, for example, Article 9, this states that member states shall take all appropriate measures to ensure the implementation of the treaties within their territories. In Shinick Maria and the state of Barbados, at paragraph 53, this court noted this imposed a requirement on states. Similarly, Article 31 uses the word shall, 32 uses the word shall to prohibit members from limiting the rights of establishments. If we contrast then the use of the word may in the RTC, where the drafters of the RTC actually intended to afford the states a discretion, they used the word may. For example, if we consider the Article 31, which allows member states to restrict the rights of establishments in public interests where they wish to do so. Therefore, we acknowledge that shall has multiple meanings in ordinary usage, but we must read this treaty as a whole and interpret it as a whole, and recognize that the consistent use of the word shall throughout the treaty is fully synonymous with must.
Yes, but in this context, surely, Council, you would admit that the word shall is immediately conditioned or qualified by the words that follow it, wouldn't you?
Yes, Your Honor, we acknowledge that Article 214 includes the stipulation that the court must have determined that the issue to be referred is necessary for them to deliver final judgment. Yes. We submit that that is not a discretion, that is a condition precedent, and there is no residuary discretion on the part of the court as to whether or not to refer once it is necessary for them to deliver final judgment.
Can you remind us of the exact wording? Because it seems to me that the wording is that if the national court considers it necessary. So, I mean, if you wanted to exclude the discretion, you would simply omit the words the national court. And you would simply say that referral must be made if it is necessary to arrive at the decision by the national court. But the framers did not do that. The framers deliberately included the phrase, if it, meaning the national court, considers it necessary. So wouldn't you say the framers intended for there to be a subjective discretion in the national court?
Your Honor, the framers intended to afford states to avoid having unnecessary referrals in the sense of if the matter is obvious or if the matter has already been ruled upon by the courts. And we submit that that precedent, that condition of necessity is obviously met in this case. When the claimant approached the court for judicial review, the claimant engaged the question of jurisdiction and procedural propriety, where the Caribbean Court of Justice has litigated extensively on the issue of the CET. It was absolutely necessary that they refer the matter to enable them to deliver a final judgment in the judicial review claim. It was simply unreasonable of them to not refer. Moreover, we also submit that the defendant cannot rely on the question of necessity for its failure to refer because the issue of referral was never engaged on any level. I also submit that the obligation is mandatory in light of the objectives of the RTC. Some of the objectives of the RTC and the Caribbean single market economy include enhancing free trade, deepening regional integration, maintaining international competitiveness. In Shinick Maria and Barbados, the court noted that CARICOM law must be uniform, predictable, and certain. We submit that this case on its facts, as it deals with the common external tariff by the claimant, which is an entity of a member state entitled to the benefits under the RTC. When the claimant was deprived of an equitable tariff, that went against the objectives of the RTC, because the RTC and the single market economy and the CET serves to promote regional producers. We also submit that on a wider scale, the issue of referral goes to whether or not CARICOM law is certain and predictable. And this is the principle adopted, this is one principle we submit that should be adopted from the European Court, which is that the referral mechanism, as outlined in the case of SPA International Chemical Corporation and Administration and Strato, the referral mechanism is for uniform interpretation of community law and affording states a discretion as to whether or not to refer essentially is inimical to the idea of homogeneous jurisprudence and regional integration. We also submit that the ultimate duty was on all the courts of defendants as to whether or not to refer the issue. The courts of defendants include the High Court of Justice, the Eastern Caribbean Court of Appeal, and the Judicial Committee of the Privy Council. Defendants have sought to rely on geographical location of the Privy Council to avoid the referral obligation. However, in defining national courts and tribunals, in the case of Dodge Consult and Berlin, the European Court set out the criteria to define national courts and tribunals as follows: a permanent body established under law, which renders judicial decisions and exercises judicial functions. We submit that all the courts of defendants satisfy this criteria.
But you know, Counsel, in our treaty, which of course is what we are guided by primarily, there is a kind of definition of national courts in Article 211, paragraph 2.
Yes, Your Honor.
And that provision says that national courts includes the Eastern Caribbean Supreme Court.
Yes, Your Honor.
Now, it's not an exhaustive definition, I grant you that. But, you know, if the framers intended for the Privy Council to be included, wouldn't it be very easy for them to have just said, includes the Eastern Caribbean Supreme Court and the Judicial Committee of the Privy Council?
Yes, Your Honor. However, the fact is that it did not include every domestic court in all the territories or every national tribunal. And
yes, because it's a rather large one at the apex.
Yes, Your Honor. However, we submit that the drafters assumed that those courts which are clearly established under the law of the territories would fall into that definition of national tribunals. And the right to the Privy Council exists at Section 99 of the Constitution of St. Vincent and the Grenadines. So therefore, and the defendant has accepted the decisions of the Privy Council as binding within its jurisdiction. So, yes, Your Honor, so the defendant cannot avoid its obligations by relying on where the court is seated. On that note, we also submit that the article is mandatory in light of the need to foster collaboration between domestic courts and the Caribbean Court of Justice. That was the purpose of the referral mechanism. It was the connecting thread or the means of dialogue between national courts and the Caribbean courts. And this, as outlined in the case of SM Jalil and Guyana at paragraph 31, the Caribbean courts is the central judicial authority that outlines rules and principles under the RTC. The courts, in turn, apply these rules and principles based on the facts before them. So it was a mutual exercise that the defendant opted not to engage in. Rather, the defendant opted to hear expert evidence and classify the seamen themselves. In my last 10 seconds, I'd like to ask the court to adjudge and declare as follows: that the defendant is liable for the failure of its court to not refer the issue of classification to the Caribbean court. And alternatively, the claimant is entitled to reimbursement for the additional 10% tax it was forced to pay from the 6th of March 2016 to the 15th of March 2016 to the 9th of August 2019. And finally, that there was no discretion on the part of the court of defendant as to whether or not to refer. It was a mandatory obligation. If I can assist the court no further, this is the extent of my submission.
Thank you very much.
Thank you.
I think you could assist us more, but the time is up. So, but you will have a reply coming up after we hear the state or the Council for the State of St. Vincent and the Grenadines. So thank you very much. In the meantime, we see you, Council. So I would suggest, I think it's Ms. Blackwood, who is the senior counsel.
Yes, Your Honor.
So if you're ready, you could address us now.
Grateful, Your Honor. May it please this Honorable Court, I am Kimberly Blackwood, and I appear as Senior Counsel on behalf of the defendant, St. Vincent and the Grenadines, in this matter. And with me today is my co-counsel, Ms. Shaquan Richards, and we are instructed by Ms. Ika Dorval. And together we will make submissions that the state of St. Vincent and the Grenadines is not liable for any alleged breach of the revised Treaty of Chagaramas. Your Honors, we wish to put forward 4 main arguments. 1, that the defendant state is not liable for the decisions of its independent national court. 2, that the Judicial Committee of the Privy Council is not a national court of the defendant state and therefore it is not liable for its decisions. 3, that Article 214 proffers discretionary powers rather than mandatory obligations. And 4, that the claimant had a duty to assist the court by raising the issue of referral under Article 214. Your Honor, on the point of state liability, we put forward the following argument: that the defendant is not liable for the decisions of its independent national court, that the defendant is not liable for the decisions of the Judicial Committee of the Privy Council because it is not a national court within the meaning of Article 214 of the revised treaty. And 3, that finding that the defendant is liable and making an award for damages would offend the separation of powers principle that guarantees an independent and an impartial judiciary. If it pleases Your Honors, I will now move to my first submission, which is the state of St. Vincent and the Grenadines is not liable in this matter because there was no duty arising under the revised Treaty of Chagaramas. Your Honors, the claimants contend that the defendant's court, by failing to refer the classification issue, breached Article 214 of the revised treaty because this issue concerned Article 82, which is relevant in respect of the common external tariff. Your Honors, we submit that that is not the case before us because the courts of St. Vincent and the Grenadines, the National Courts of St. Vincent and the Grenadines, were never concerned with a matter concerning the interpretation or the application of the revised Treaty of Chagaramas. Your Honors, my co-counsel will further submit arguments in relation to the discretionary powers afforded by Article 214. But I would like to submit to this honorable court that in respect of this obligation or in respect of this duty, it did not arise because the National Courts of St. Vincent and the Grenadines were not seized of an issue whose resolution required this court's intervention in order to enable it to deliver a decision.
Just to help me to follow your argument, counsel, are you saying that the High Court of St. Vincent and the Grenadines was not seized in the way you described, but that the Controller of Customs was seized?
Your Honor,
because the issue apparently before the Controller of Customs had to do with classification, and classification is quintessentially an issue that will be decided by court or by community organs. So are you drawing a distinction, just for my clarification, between the decision-making process in the Controller of Customs versus that in the High Court?
Your Honors, we submit that the High Court of St. Vincent and the Grenadines, the matter was one for judicial review, and therefore the concern of the High Court of St. Vincent and the Grenadines was the procedure by which the Controller had come to his decision. The procedure was the procedure by which the Controller had come to his decision.
I think, Ms. Blackwood, that is a kind of old-fashioned way of looking at these judicial review, because it has clearly been said several times that judicial review also may have a substantive element in it, because a lot of judicial review is also seen through the lens of the constitutional values that play a role. And so it is, in this case, as we suspect, the controller decided on whatever information he had that the classification of this kind of cement should be X. And of course, the claimant in this case did not agree, and they went to the court, and the court somehow decided, and that was affirmed in the Court of Appeal and the Privy Council that whatever method the controller used was correct, as Justice Anderson just pointed out. This is a matter for quartet that has been established for some time. So it seems to me quite clear that there was an issue which touched at least on the interpretation of the revised treaty. Who is responsible or who is seized with deciding what the correct classification is. That's all in this, seems to be all in the sphere of the CET. And if that is so, then it would seem quite obvious that it touches on that, on the interpretation of the revised treaty. What do you say to that?
Your Honors, we submit that in this matter, the courts of the High Court of St. Vincent and the Grenadines were concerned. We're not concerned with an issue that whose resolution concerned the interpretation or the application of the revised treaty, Your Honors. Rather, in respect of that, Your Honors, we submit that the courts of St. Vincent and the Grenadines were concerned with how this comptroller had come to his particular decision. And in considering this, Your Honors, we submit that the courts of St. Vincent and the Grenadines would have been concerned with the things such as whether or not his decision was irrational based on the scope of his duties, whether or not it was unreasonable within the scope of his duties, whether or not, Your Honors, there was some procedural impropriety. That is what the courts of St. Vincent and the Grenadines would have considered. Your Honors, if I may also direct your attention to the case of TCL 2019, Your Honors, where in terms of judicial review, Your Honors, this court was never, in terms of the judicial review of the decision of quoted, Your Honors, this court was never concerned with the decision itself of quoted, but was concerned rather, as the state of Trinidad and Tobago had raised, whether or not such a decision would have, whether or not quoted had relied heavily on the world's customs organization, instead of relying on the community law, based on the application of the community law, based on the way in which quoted applies to the community.
Yeah, but there was a decision before this one. The decision that you mentioned, and it was built on another decision where Trinidad and Tobago, for example, said, well, that's our own business, how we classify, for example, goods. And the point was raised, okay, is that a national issue now that we have a common external tariff? Or is this an issue which can only be decided by quoted? And then, of course, how should quoted do that and all of that? And in that decision, it was said by the court, yes, quoted is the way to go. And we will supervise that process as a court. So that was a decision which was taken in 2018, and that was the precursor to that decision that you mentioned.
Yes, Your Honors. However, in that very decision that you mentioned, Your Honors, this court held that while quoted does have the ability to hear it, it does not have the exclusive jurisdiction, and therefore, if parties seeking a resolution have the option to also bring it before the courts of the member states as prescribed by the law, or this honorable court itself. Yes,
but okay, so you know that decision, that's very good. And so then you know that the court said, well, there are actually three ways of solving a problem like this. And the second one was this. The second says either party, so that could be the company here and the controller or the government, either party may seek resolution of the dispute before any court or tribunal as prescribed in the relevant laws of the member state concerned. Where the classification dispute involves a question concerning the interpretation or application of the revised treaty, the court or tribunal shall, under the terms of 214, refer the issue to this court for determination. So it said, yeah, you can go to your own court, but as soon as it touches, of course, now you could argue it doesn't touch any interpretation, but as long as it does, the court even indicated, well, then there will be a referral to our court and we will deal with it. So,
Your Honors.
So what is your point?
Your Honors, in response to that particular paragraph or that particular mention of that case, Your Honors, we submit that this honorable court in that case had ensured that Article 214, specific mention of Article 214 was established. And in Article 214, it did say, Your Honors, that the national courts of the member states are only obligated to refer an issue to this court if it is seized of an issue whose resolution would need this court's intervention in order to enable it to deliver judgment, Your Honors. And we are submitting that was not the case in this matter, because
Yeah, I think that's an issue that your co-counsel will further develop. Eh?
Yes, Your Honor.
Yes.
Okay.
So anyway, so you're saying, well, this did not concern any interpretation of the revised treaty, and so there was no duty to refer. But supposing there was a duty to refer, you would still say there's no liability?
Your Honors, if this court finds that there was a duty and the state of St. Vincent and the Grenadines is in fact in breach of that duty, we submit that this honorable court in the case of TCL and Guyana 2009 CCJ 5 OJ, hereinafter cited as TCL 2009 CCJ 5, noted, Your Honors, that there are conditions which must be satisfied in order for an award of damages to be made for state liability. Now, Your Honors, we submit that these conditions are that the provision which was allegedly breached must have been intended for the benefit of the claimant, and that such a breach was serious, and that there was substantial loss, and there's a causal link between the actions of the defendant and the loss suffered by the claimant. Your Honors, we are submitting that none of those conditions have been satisfied here. Your Honors, on the point that the provision allegedly breached must have been for the benefit of the claimant, intended for the benefit of the claimant, we submit that this court in the case of TCL Guyana 2009 CCJ 1 noted that where there are implied obligations, there are conferable rights to private entities. Your Honor, however, we submit that in light of the present circumstances, that obligation did not arise based on the fact that our courts were not seized of an issue whose resolution would have required the intervention of this honorable court. Your Honors, on that point, moving further from that point, Your Honors, we submit that in this present case, because there was no such obligation, then the implied right, then the right which would have been conferred on private entities in this matter did not exist. Now, Your Honors, on the point of the seriousness of the breach, Your Honors, we submit that in light of that point, the case of Kobler enunciates, Your Honors, that in order for the breach to be classified as sufficiently serious, then the national courts of last instance would have had manifestly infringed, Your Honors, the applicable law, which would be Article 82 and 214 in this case. Your Honors,
if I may, so is it that you think the court should apply Kobler, that Kobler decision, which of course says they recognize the state unity doctrine, so that yes, in certain circumstances, even if a court, independent court, does something wrong, it could create liability for the state. But there are a lot of restrictions before you get there? Is it that you suggest that we should adopt that jurisprudence?
Yes, Your Honors, particularly on the point which notes that, particularly on the point which characterizes the seriousness of the breach. Because, Your Honors, in that particular case, it was noted that factors to characterize the seriousness of the breach would include whether or not the breach was intentional, or whether it was inexcusable or excusable. And we submit to this honorable court, Your Honors, that in light of the present circumstances, given that the courts of St. Vincent and the Grenadines would have reasonably assumed that the matter did not concern the interpretation or application of the treaty, then such a breach was not intentional. Your Honor, I could
follow the argument you make, counsel, if you are thinking of damages in the broad sense of the term, and you're saying that, you know, unless the court misbehaved to that extent, then damages, you know, ought not to be awardable. But in this case, we're not so much talking about damages at large. We're talking about simply the reimbursement of taxes that were paid, which apparently ought not to have been paid. So would the cobbler criteria apply in this specific instance where we're talking about not damages at large, but simply the fact that the government was unduly enriched by having received extra taxes that it had no right to?
Your Honors, we submit that on the point of unjust enrichment, that the state of St. Vincent and the Grenadines was not unjustly enriched, because, Your Honors, there was no breach of duty, because there was no wrongful conduct. Your Honors, in the case of Rhodesia Beverages and Guyana, the court held, Your Honors, that for there to be unjust enrichment, there must have been wrongful conduct, Your Honors, from which the state would have derived some benefit. And, Your Honors, we are asserting that no such wrongful conduct existed because there was no breach of duty. And therefore, the claimants in this matter the defendants in this matter, Your Honors, the state of St. Vincent and the Grenadines would not have been unjustly enriched given the circumstances.
Counsel, I want to take you back to cobbler to ask you a little different question to what my brothers have asked so far, but having regard to the express language in Article 214, do you think we ought to adopt the criteria in cobbler?
Yes, Your Honors. I believe this court ought to adopt the criteria in cobbler, because in that particular case, Your Honors, the state liability was clearly, Your Honor, discussed, and also the provisions of Article 177 of the EEC, which was discussed in the case of cobbler, mirrors or Article 214, which my co-counsel will also detail. Your Honors, at this time, I ask the court, but I may move on to my further submissions in the interest of time.
Sure.
Grateful, Your Honors. So, Your Honors, we move to the point that once again in the difference between the actions of the state of Guyana in the TCL case of 2009, it was vastly different from the actions of St. Vincent and the Grenadines, and this court characterized what a serious breach would be in those instances. Your Honors, we submit that the state of St. Vincent and the Grenadines, as soon as we were made aware of the decisions of this honorable court, adopted that decision immediately. We also wish to submit, Your Honors, that had this court, had the claimants raised the issue within the National Courts of St. Vincent and the Grenadines, we would have immediately stayed the matter and would have brought it before this honorable court. Further, Your Honors, we submit that also in light of the case of
counsel, your opponent said, well, but the state could also have raised the issue.
Your Honors, grateful for that question, Your Honors. My co-counsel, Mr. Kwan Richards, will detail further the issue of referral in the matter. Yes, Your Honors. So, in light of that, Your Honors, I move quickly to my second submission, which is that the Privy Council is not a national court within the meaning of Article 214 of the treaty. Your Honors, Section 10 of the Caribbean Court of Justice Act of St. Vincent and the Grenadines has been has incorporated Article 214 of the revised treaty, and Your Honor, Section 5.6 has incorporated Article 211. And by virtue of this, Your Honors, Section 5.6 states that the National Court includes this National Court is the Supreme Court of the member state and includes the Eastern Caribbean Supreme Court. We submit, Your Honors, that on this point, the Privy Council would not be classified as a National Court of St. Vincent and the Grenadines because the reference that is made to the Privy Council in sections 96 to 99 speaks only to the jurisdiction of the Privy Council, Your Honors. And what we state is that paragraph 8A of the second schedule of the Constitution of St. Vincent and the Grenadines, Your Honors, specifically outlines that the Court of St. Vincent and the Grenadines, that the Supreme Court of St. Vincent and the Grenadines, by virtue of the Supreme Court order, shall be the Eastern Caribbean Supreme Court, and not only in the Supreme Court order, Your Honors, but also within any other prescribed law of St. Vincent and the Grenadines, and that would include, Your Honors, Section 5.6 of the CCJ Act. Now, Your Honors, we submit that by.
Would that mean then that the Privy Council can decide whatever it wants? So what remains of uniformity of the CARICOM community law?
No, Your Honor.
But they don't have to refer. In that case, they don't have to refer, so they can decide whatever they think fit, which would not necessarily be the same as this court's jurisprudence or interpretation of the treaty. So how would that work?
Your Honors, we submit that any issue of referral would have needed to be made before it went to the stage of the Privy Council. Your Honors, because what this means is, again, based on the Eastern Caribbean Supreme Court, which comprises the High Court and the Court of Appeal of St. Vincent and the Grenadines, it would have been necessary to, at the stage of the Court of Appeal or at the High Court, stay the matter if the claimant so believed, to ensure and refer and suggest that this issue be referred because it would have been seized if it were seized of this issue, Your Honors, which in our present case, it was not.
But it's an interesting point to raise there, Counsel. So if we were to go along with you that the Privy Council is not a national court of the member state, how does that help you? Because you have two national courts that did not refer, the Court of Appeal and the High Court. And even if we went along with you as well on the issue that the judicial review in the High Court did not constitute proceedings from which there ought to have been a reference. Are we sure that decision of the Controller of Customs doesn't constitute kind of court from which there ought to have been a reference as well?
Your Honor.
So even if we were to give you your argument on the Privy Council, isn't the state still liable for the failure of the Court of Appeal and certainly the High Court, possibly the Controller of Customs?
Your Honor, in this matter, we once again suggest that there was no duty to refer under Article 214 because the matter did not concern the interpretation or application of the treaty. And Your Honors, we also wish to submit again that the classification issue based on the decision of TCL 2018, if the claimants believe that there was in fact a classification issue, then they would have been able to bring the matter before this honorable court itself under Article 222. Your Honors, may I please move further into my submissions?
Well, you're out of time, so you will we had a lot of interruptions, so do it in 2 minutes.
Gratefully, Your Honors. Your Honors, we submit that on the point of the Privy Council not being a national court, we submit that based on Section 5.6 of the Caribbean Court of Justice Act of St. Vincent and the Grenadines and Article 10, Section 10 of the Caribbean Court of Justice Act of St. Vincent and the Grenadines, and a reference to Article 214, Your Honors. The Eastern Caribbean Supreme Court would, though a regional court, would be for the purposes of the treaty be construed as a national court. Your Honors, we also wish to submit on the point of judicial independence, and that this honorable court finding that the decision of the independent court were in breach of the treaty, Your Honors, would in fact offended this principle of separation of powers. Because, Your Honors, what would happen is that the floodgates would now be open for matters for courts or for private entities like Vincement Limited, multi-million-dollar companies, to come to this court on matters only when the ruling of the national court was not in their favor. Your Honors, we submit that this is a direct threat to the rule of law, and we submit that this is a direct threat to objectivity and fairness within the national court. Because what would happen, Your Honors, is that the judges within the national courts, Your Honors, would be constrained, Your Honors, to rule in favor of these corporations in fear that they will bring such matters to that's
not expressing very much confidence in the judges' counsel.
Your Honors, it is expressing confidence, Your Honors. However, we wish to highlight that the state of St. Vincent and the Grenadines is a small island state, Your Honors, and these lines must be clearly distinguished. And in respect of the confidence of our judges, Your Honors,
we have some very excellent judges coming from small islands such as St. Vincent and the Grenadines.
Your Honors, we are very much aware of that, such as the president of this honorable court, the Honorable Mr. Justice Adrian Sanders. We're very much aware of that, Your Honors. However, we do not want the judges of these small island states to be constrained by virtue of the fear that they are going to that corporations or private entities such as Vincement Limited will bring claims against them, frivolous claims against them for their decisions.
It's claims against the state, of course, not against them.
Yes.
And I don't know if a high court judge feels constrained because the losing party can appeal to the Court of Appeal, etc. I mean, that is a point I have difficulty understanding. But you made the point. I think you got even more than 2 minutes, so we have to finish here. You can just say 1 or 2 sentences to close off.
Your Honors, on this point, we submit that the state of St. Vincent and the Grenadines is not liable in this matter because there was no breach of duty under the Rights Treaty. I now yield the floor to my co-counsel.
Yes, thank you very much. This is Ms. Richards.
Yes, Your Honor.
Yes.
May it please you, Your Honors, my name is Shaquan Richards, and I appear as junior counsel on behalf of the defendants in this matter. I'll be addressing 2 issues. Firstly, that the defendants' national courts had a discretion to refer the matter to this court. And secondly, that the claimants in this matter had a duty to assist the court by raising the referral issue. Your Honors, we submit that this court ought to take into consideration the wording of Article 214 when construing the article. And this point was illustrated in the case of Doreen Johnson and the Caribbean Center for Development Administration, 2009 CCJ 3, in the original jurisdiction of this court. Your Honors, and so I invite you to turn with me to Article 214 of the revised treaty. Article 214 states that where a national court or tribunal is seized of an issue which involves the interpretation or application of an article of the revised treaty, it shall, if it considers that a decision on the question is necessary to enable it to deliver judgment, refer the matter to this court. Your Honors, we submit that there are 2 preconditions for referral, and if these preconditions are not satisfied, the duty to refer cannot arise. Your Honors, the first precondition is that the national court or tribunal must be seized of an issue that involves the interpretation or application of the revised Treaty of Chaguaramas. Your Honors, the claimants have submitted that the national courts were concerned with the application of Article 82 of the revised Treaty of Chaguaramas. However, we submit that the national courts were not concerned with the application of Article 82 of the treaty. Article 82 says that member states shall establish and maintain a common external tariff in respect of all community goods, which do not qualify for community treatment, and shall, in accordance with the plans and schedules set out in relevant quoted determinations, that is the Council for Trade and Economic Development. Your Honors, my clients did not at any time suspend the common external tariff to be applied to Vincement Limited Cement. Further, Your Honors, the national courts of St. Vincent and the Grenadines were not seized of the issue of application of Article 82 because the claimants never raised the classification issue in my client's national courts. And so on that basis, we submit that the national courts were not seized of the issue. Further, Your Honors, at paragraph 4.3 of the claimant's submissions in reply, they've stated that my clients were asked to hear judicial review proceedings in the matter, but pronounced on the classification of Vincent Limited Cement. Your Honors, we submit that this was not the case, as they have seemingly read paragraph 1 and line 6 of the court's brief as inserting a paragraph, rather a comma, after comptroller, and this gives the sentence an entirely different meaning. And so we submit that the claimants have failed to consider the fact that my client's national courts were concerned with judicial review proceedings, and so the scope of the case was restricted in that light. Your Honors, the case of Leacock and the Attorney General, BB 2005, HC 24, at paragraph 26, notes that the court is not required to consider the merits of a decision, but must consider the process by which the decision-making authority came to that decision.
Are you saying that there can never be a judicial review case before a high court which raises an issue that touches and concerns the revised Treaty of Chaguaramas?
I am saying, Your Honors, that no, Your Honors, that's not what I'm saying. What I'm saying is, in judicial review proceedings, the court is restricted, and so they're not required to consider the merits of the decision. So the merits of the decision in this case, Your Honors, would be how or why rather the comptroller classified the cement as he did, and so he would have had to, or rather the courts could not consider the technical the composition rather of the cement and matters such as that. But Your Honors, the courts were considered with whether the comptroller had properly exercised his duties under the law. And so, Your Honors,
but could procedure also not entail whether the comptroller could decide this on his own, whether he should not have, for example, turned to COTAT, because it is a classification which is a thing that fits into this common external tariff, which is surely not only a matter for St. Vincent and the Grenadines, but for all community states, member states of the community. So that couldn't that have been a question that could have been raised?
Yes, Your Honors, it's possible that could have been raised. However, we're not entirely certain what the complete scope of the judicial review proceedings were in this, particularly because of what was presented before us in the facts. So, Your Honors, we submit that the first precondition for referral was not satisfied in this case, and so we cannot be, or the state of St. Vincent and Grenadines cannot be liable on that point for failure to refer on that point. Your Honors, the second precondition is that a decision on the issue of community law must be necessary to enable the court to deliver judgment. Your Honors, I refer to the case of H.P. Bulmer Limited and J. Bollinger S.A. 1974, Volume 2, All England Reports, which is found at page 1226, and I'm particularly referring to page 1234. Your Honors, the Court of Appeal of England and Wales considered set out the conditions to be taken into consideration by national courts when deciding whether a decision on the question is necessary to enable that national court to refer matters to the treaty court. Your Honors, we accept that the wording of Article 214 of the revised treaty and Article 177.2 of the treaty establishing the European Economic Community, which was the article that was being considered in that case, are not identically worded. However, the precondition that a decision on the question must be necessary to enable the court to deliver judgment is applicable or is present in both articles. And so, Your Honors, we submit that this case is persuasive precedent for my client's national courts to decide whether a question on the decision is necessary to enable the court to deliver judgment. And so, Your Honors, the first condition is that the issue before the national courts must be conclusive of the case before it. Your Honors, we submit once again that Article 82, the application of Article 82 was not before my client's national courts, and therefore it cannot be said that this issue was conclusive of the case before it. What was before my client's national courts was a matter for judicial review. And so on that basis, we submit that the first precondition, or the first consideration, was not fulfilled. Your Honors, the second consideration is that where there's a previous ruling by the treaty court, which would be this honorable court, in our circumstances, the national court may rely on a precedent that is set out in a decision that concerns a similar question. Your Honors, we submit that this consideration is not applicable here, as at the time of my national court's decision, there was no precedent on this particular issue, that is the classification issue. And in any event, as we previously indicated, the issue of classification was not before my client's national courts. The third consideration, Your Honors, is acte clair, that it was reasonably clear to the national courts that this issue was reasonably clear to the national courts. Your Honors, we submit that it was reasonably clear to my client's national courts that they were considering a matter for judicial review. And so they were constrained in their approach in that they were not called upon to adjudicate on the classification of Vincent Limited Cement. Further, finally, the last consideration, Your Honors, is that a decision, or rather the national courts are required to decide on the facts first. Your Honors, we submit that having decided that, again, this was a matter for judicial review, as the case was before them, the national courts would not have considered that a decision on the question of Article 82 of the revised treaty was necessary to enable them to deliver judgment.
But it seems they heard expert evidence. So doesn't that give a clue that they may have gone into the substantive issues too?
No, Your Honors. We submit that the expert evidence that they heard was in relation to the exercise of the comptroller's duties, in that whether he was allowed to hear, whether he was allowed to classify the cement, whether he had acted irrationally in terms of the grounds for judicial review, whether he had acted irrationally, whether there was any procedural impropriety in his exercise of his duties, Your Honor. The brief, Your Honor, must be read in light of the fact that the courts heard a matter for judicial review, and so again, were limited in the scope of their decision. Your Honors, we further submit that the discretion conferred under Article 214 is in keeping with the object and purpose of the treaty. Your Honors, the case of Jamili Hadid and the Attorney General of Trinidad and Tobago, which the claimants have cited, notes at paragraphs 1 and 2, that the aim of the treaty is regional cooperation between states. Your Honors, we submit that the mechanism for referral under Article 214, particularly discretion that is conferred, allows the national courts to act as a filtering system to ensure that matters which do not fall within the conditions set out under Article 214 are not referred to this court and result in a wasting of the court's time. Your Honors, if there are
we can say that no national court has been guilty of that up to now.
Yes, Your Honors. And Your Honors, I will now move to my last submission, which is in respect of the claimant's duty to assist the national courts of St. Vincent and the Grenadines. Your Honors, counsel has a duty, that is, every counsel has a duty to raise every issue and ask every question that would assist their client's case. And this point was noted in the case of Rondell and Worsley, Your Honors. Further, Your Honors, the Eastern Caribbean Supreme Court Civil Procedure Rules, Rule 1.1, notes that the overriding objective of the court is to deal with matters justly. And Rule 1.3 of the same Civil Procedure Rules notes that clients, or rather parties, have a duty to assist the court in achieving the overriding objective. And Your Honors, the overriding objective includes saving expense and dealing with matters expeditiously, as well as allotting to each case an appropriate share of the court's resources. Your Honors,
Counsel, I was trying to find whether the reference was made in the brief from your opponents. I've not been able to locate it, but there is authority from the European Union which says that the failure of a party to raise an issue of community law does not preclude the national court from itself referring that issue to the, as you said, the treaty court. In other words, a failure by the parties in this case would not obviate the requirement for the referral. How would you respond to that suggestion?
Yes, Your Honors. The point is that the classification issue goes to the heart of the case that the claimants are now arguing, Your Honors. And so if it was that they ought to have recognized that this classification goes to the heart of their case, and so ought to have presented the issue to my client's national courts so that
I am not disagreeing with that. But what I'm saying is that this authority seems to say that even in the absence of their raising the point, the obligation is not, well, the national court is not precluded, it says, from making the reference.
Your Honors, we accept that, but again, this question would have gone to the heart of the claimant's case. And so they ought to, again, if the court was not seized of the issue, this goes back to the preconditions set out in Article 214, because the claimants are saying that we failed to refer in breach of Article 214. And so, but the fact is that the classification issue was not before our national courts. And so we were not seized of an issue requiring the application or interpretation of Article 214. And so therefore, Your Honors, there could not have been a breach of duty. Further, Your Honors, with respect to the claimant's duty to assist.
You are out of time, but we give you another two minutes to round off.
Thank you, Your Honor. So the claimants had a duty to assist the court by furthering the overriding objective. Your Honor, if the claimants had raised the referral issue, this matter would not have been protracted in my client's national courts. You know, as my senior counsel had previously indicated, the claimants had the option to bring the case they're bringing now, Your Honors, in terms of with respect to the classification issue. They had the option to raise the classification issue with my client's national courts, and they failed.
So are you saying that if they had raised the issue in a judicial review proceeding, it would have been okay to refer the matter to the CCJ?
Yes, Your Honors. And so, Your Honors, their failure to raise the referral issue has resulted in the matter being protracted in my client's national courts.
But I thought you were saying earlier that judicial review proceedings are not the venue for making those kinds of referrals.
Yes, Your Honor, it is not. And so, my apologies, I retract the answer to your question earlier. Your Honors, the fact of the matter is the claimants they used the incorrect proceeding to raise this issue, because the heart of their case is the classification issue. And having failed to put it before my client's national courts, there is no way that my national courts could have assisted the claimant in having the matter properly resolved, Your Honors. And so, further, Your Honors, by failing to raise the referral issue, they have resulted, the matter has protracted in my client's national courts and has resulted in 3 years of litigation over this matter that was not properly raised because the claimants failed to get to the heart of the issue. Your Honor, unless I may be of any further assistance to the court, these are my submissions.
Thank you very much. Going back to the counsel for claimants, you have, if you wish, a right to reply, not longer than 5 minutes. Do you wish to use that? Mr. Lala?
Yes, Your Honor, we wish to proceed with the rebuttal.
With the reply. Okay. Just to make it clear, the court understands you were not the lawyers in the domestic courts.
Yes, Your Honor.
So you can speak freely.
Thank you, Your Honor. Your Honors, this is a case about a tariff which all states are required to keep at a certain level. The only court with the requisite authority and jurisdiction to essentially police this tariff is the Caribbean Court of Justice. And therefore, we are here today at the right forum, we are here today before the right court, and we are here today with a just case which the other side has accepted that they are bound by. In accepting that they came to a wrong classification with regards to the claimant's cement product, they accept that it is as a result of their actions in not referring this issue and subsequently classifying the claimant's cement and wrongly at that, which directly caused the claimant to have to pay this additional tax payment for 3 years, 4 months, and 21 days.
Yes, sorry, Mr. Lala, with respect, I seem to feel that this is familiar territory we are traversing again. And I would like for you, please, to respond to interesting point made by the other side, which was to do with the nature of the proceedings. And they're saying that these are judicial proceedings, which of course have a certain compass in our systems, and that there was no obligation to make the referral from the judicial proceedings. If this was an appeal, they are saying it would be different. But this was not an appeal, it was in fact judicial proceedings, and therefore there was no obligation to refer. I think that was the heart of what their case was. Do you care to respond to that?
Yes, Your Honor, of course. And we acknowledge that the claimant instituted judicial review proceedings. And these types of proceedings focus on procedure, yes. However, even when these proceedings are instituted, judicial review includes issues of rationality. And therefore, rationality would include a consideration of whether the controller correctly came to a proper conclusion on the classification of the claimant's cement product for the purposes of applying the common external tariff, which remains a pivotal part of the revised Treaty of Chaguaramas, and therefore this issue directly concerned the revised Treaty of Chaguaramas, and there was an obligation on the national courts of the defendant to refer this issue to the CCJ, which was the only court with the requisite authority to decide on it.
In answer to the question of whether there was rationality or not, one answer could be, well, expert evidence was adduced, and therefore that answers the question as to whether anybody was acting irrationally.
Yes, Your Honor. However, with regards to the decision and the procedure which was applied in coming to that decision and classifying the claimant's cement product, we acknowledge, and as this court has acknowledged in the Rockard Cement case, they came to a wrong classification, and therefore in these proceedings, despite it being judicial review, the matter, they came to a wrong conclusion, and despite it being judicial review, this ought to have been considered, and it being an issue which directly concerned the application of the CET, a critical part of the RTC, the obligation fell on the national courts of the defendant to then refer this issue, which they failed to do, and which they subsequently incorrectly classified the claimant's cement product, overstepping into the exclusive jurisdiction of this court. And Your Honors, on the point of state liability, which the defendant's claim has not been satisfied, we note that this is a substantial and serious breach by the defendants in this case. It is a manifest infringement of Article 214 in that, in failing to refer, They would have breached both their international and domestic obligation on the point of referral. They infringed and usurped upon the exclusive jurisdiction of this court in classifying the claimant cement product. And they came to an incorrect conclusion. And therefore, this directly resulted in the substantial losses which were faced by the claimant in these proceedings. And therefore, the defendant cannot claim that state liability does not exist in these proceedings, while acknowledging that the Cobbler principle does in fact apply. And therefore, in addition, the defendant cannot conveniently try to distance itself from its own apex court when the very constitutional provisions, specifically Section 99 of their own constitution, delegates the Privy Council as such. And therefore, this contention by the defense is contradicted by their own constitutional provisions. And as such, we submit that this obligation was a mandatory one, it being an issue which directly concerned the RTC. It went to the heart of this treaty and it ought to have been referred. St. Vincent and the Grenadines were obliged to refer this issue, and they failed to do so. And we implore this honorable court to hold the defendant as a state liable for its egregious and blatant breach of Article 214 in these proceedings and promptly reimburse the claimant the additional tax payment they had been forced to pay as a result of the unlawful, inaccurate, and ultra-virus tax payment forced upon it by the defendant.
Are you asking for interest as well or not?
Sorry.
Are you asking for interest on the taxes or not?
Definitely, Your Honors. And if I may be of no further assistance to the court at this time, this will be the extent of my submissions. Thank you.
Thank you very much.
Thank you very much.
Okay, counsel. As soon as we have closed off, the court will withdraw. We will deliberate on your submissions. The court will be back at 11:31. There we will give a feedback and comments on all the presentations, not only yours. We will give an indication of how we think this case could have been solved. Well, then we'll follow further proceedings where the winners will be known and all of that. So I call on the Deputy Registrar to close off these proceedings.
Thank you, Mr. Justice Witt, Mr. Justice Anderson, and Madam Justice Rajnath-Lee. Thank you, Counsel, Team Lead, Moot Registry, staff of the Caribbean Court of Justice. This matter now stands as adjourned. Good day to all.